Hi, everybody, and welcome to Raw Law. This is the show where we answer your questions and we talk about your comments live. We are here live from my office in Brooklyn. This is Tuesday, August 5th today. And so I'm just going to pause my notifications so I could give you guys my undivided attention. Okay, so let's get into it. Let's answer some of these questions and get into it right here. So I see the first question. I'm going to go back up. The first question is from Manny, and he says, "Hi, Arkady. Question: I'm going to mediation this coming week. My attorney said they have 9 million with the extension. He submitted a lawsuit for the amount. Now he said we should settle close to 3 due to the medical cost multiplied by 2 or 3. I sent him a letter requesting clean for me at least 3.7 with my 2 ACDFs, and he lists some surgeries, truck accident. We are going to mediation again 2 weeks after the first one. What should I do? I wanted 4 clean. Should I go to court? The driver is deceased and they are 100% liable. His statement was he was changing lanes, didn't see me. And there was also a lumbar surgery." I mean, it's hard for me to say, based on a comment, but it sounds definitely like it's a big case. And I don't like the idea. I think I've said it before. I don't like the idea of, putting a value on a case based on medical bills. Like some people do that. They'll say my medical bills are X. So 3 times medical bills is how much I should get. I don't like that. I really think that's a bad way to do it. I know a lot of states, that's how they reach settlements, but really you have to look at the overall impact to somebody's life, to your life, how you've been impacted. Of course, you having 2 anterior cervical discectomy and fusion surgeries is going to have tremendous value. That is going to have tremendous value, but it's the overall impact to your life, right? If you've missed time from work, if it's affected your family, your ability to play with your kids, your family, your friends, your activities, that's where you're going to get the most value. So you have to really sit down and do like an exchange of photographs, what you were doing before, what you're doing now, maybe videos. You could do a full like biography type human story with the attorney. The attorney should be involved in that. So I don't know a lot of things about this. Like I don't know where this is, what city, whether the attorney that's telling you this is a trial attorney that's won these numbers. Like you're saying you want 4 million for yourself, right? But has this attorney, have they recovered 4 million either with settlements or with verdicts? Because if they haven't, then it's unlikely you're going to be the first person, right? I mean, possibly you'll be the first person for them to do it, but you want to see somebody who has a track record. So there's a lot of other things we have to look into. But yeah, I mean, it sounds like definitely the case has a lot of potential. But the best thing to do for something like that, 'cause you're really asking for like a personal consultation. So for that, better to text me. It's 347-566-9595, and we can jump on a call. I actually did 2 of them today. One with a lady in New York and another one with a gentleman in Georgia, in the state of Georgia, near Atlanta. So I'm happy to do that, and then we could really talk about everything and I can give you some advice, but it's hard to do it, in a YouTube comment. Okay. And then M YouTube page says, "Hi, Arkady. I finally made it to the trial part of my case. What usually happens in the first trial conference? Do they start to pick the jury? Conference is 11/17, Nassau County Supreme. Thank you." No, so the trial conference is just where they, conference the case. It's like a pretrial conference. The picking the jury part happens when you actually, start the trial. That's the actual trial. So you'll be told like you have a trial date, and then you have to go. Your lawyer, you don't have to be there. You can, I believe, as a party, but the lawyer usually does it by themselves. And so they go into a jury selection room and they speak to, let's say, 20 jurors, and they start asking them questions and seeing who would be a good juror for this type of case and who maybe is not the best type of juror for this type of case. And then they're selecting jurors. And then the jurors that are good for this case are kept on the jury. And then those who aren't are left off. There are cause challenges. You can get somebody off for cause. And there's also preemptory. You have unlimited cause challenges, but preemptory, you only have 3. So that's going to happen probably when you have the actual trial, not the conference. The conference is just like a pretrial conference where they're setting a trial date. They're seeing maybe one last time if the case could be settled, things like that. Okay. And then Virgo says, it says in my medical records that I'm legally blind. Nobody ever told me. Is that a disability? And can it help prove liability in a trip and fall case to combat the open and obvious defense? Apparently, my legal blindness is a consequence of my cerebral palsy at birth. I mean, it could be, right? Like if you're legally blind and you're not able to see, then, it'll be hard for them to say that, hey, you should have seen whatever it was that you tripped over, right? If it was like a defective condition and they're saying, well, you tripped and fell over this and it was open and obvious, you should have seen it. Well, wait a minute. If I'm legally blind, you take your plaintiff as you find him or her, and that might be a pre-existing injury. That could also be their ability, right? So if your ability to see is diminished, then if it's, I believe this is the one that happened in a store, right? So it's like a supermarket. So in a supermarket, they have to account for that, right? Some of the shoppers could be legally blind, right? Some of them might not be able to walk, might be in a wheelchair, right? Everybody has different abilities, just like some of them might be really young, like 3-year-olds, they might run around, push each other. Some of them might be really old, like 89, 90, they could also be more frail. So they have to take into account, everybody's abilities and be safe. So I think, yeah, definitely that's an argument you could use. And then Carl says, how much are laminectomies worth in general in a good venue like Brooklyn, Queens? Young plaintiff, million policy, good liability, 2 additional arthroscopic surgeries plus the laminectomy. I mean, if you have all that, like 2 arthroscopic plus a laminectomy, I would say it's worth the full million. I mean, why would it be worth less? A laminectomy, I mean, I've had verdicts, even this is going back a long time ago. I'm just thinking of a case. This was, I think, when was that case? That was a while ago. That might have been like 2001. It was really old. When I first started, yeah, I think it was like 2001, 2002, we had a trial and it was a laminectomy. And I think we got 1.6 million. And that was back then. So now, with the cost of living, with all the increases, with things being, this is like 20, 25 years ago, 2001, 24 years ago. So yeah, I mean, I think definitely it's worth more than $1 million. You might have to go to trial though. So the key thing is, make sure the case is prepared correctly, make sure you have a real trial lawyer on it, but it could be worth way more. It definitely. And plus the 2 arthroscopic, I mean, arthroscopic are already worth like 150, 200 for one. If you have a second, it might not double it, but it might make it worth like 350, 400 or more. Those are like the baselines. It could be much more, but with a laminectomy, that's a pretty big injury. So if you have a good liability and you're in a good venue, yeah, I don't really see any issues. Okay, and then Noise says, I had multiple surgeries due to my accident, leading me to be bedridden. I developed a blood clot and had to have an emergency surgery. How much case value would that add? It had an emergency thrombectomy. Yeah, I mean, like it's hard to say. I'd have to know more about the underlying accident. What's the accident about, right? How much insurance is there? What venue are you in? Because it's all going to depend on that. It's all always different. It's not the same. Oh, okay. Okay, 1 second. I'll be right back. I have to do something. I have someone at the door. Sorry. I'll be right back in 1 second. Oh, okay, I'm back. Sorry about that. I just had someone at the door. I had to do something. But let me see. So let's go back to this question. Which one? Oh, the multiple surgeries, right? So, yeah, so I think that, it definitely adds value because if you developed a blood clot and you had to have emergency surgery for that, and that, is a consequence of the underlying injury. I mean, I can't tell you exactly how much that would add, but that would add a significant amount because it's so debilitating and so life changing having a emergency thrombectomy and being worried for your life and then all of the consequences of having that surgery. So I would say it should add a significant amount. It should be at least like a few 100,000, maybe even more than that, but I have to know about the overall case to evaluate it, the overall case, like what's the underlying case about, how much insurance there is. Because if the underlying case, let's say, is a car crash and there's only 100,000 insurance, well, then I can't tell you, hey, it's going to add to 500,000 because you only have 100,000. You know what I mean? So I'd have to know what the underlying case is about. Then I could tell you more. So that would be better for a consult too. And you could do that with just by texting me 347-566-9595. And then Paul says, how long does it take to get payment after your workers' comp case is settled? Papers have been signed, and this is in New Jersey. It shouldn't be long. I mean, maybe a month. I'm not really sure because I don't do workers' comp, and I'm not, I don't know about New Jersey. But New Jersey, from what I've heard, is pretty quick. It's pretty efficient, so it should be better than New York. New York is a little bit slower. But yeah, from what I've seen, workers' comp, it doesn't take too long. And then Secreting says, if a lawyer keeps pushing for surgery on a lien, does that mean they're confident the case will settle high enough to cover it and still leave me with a solid payout? I wouldn't want to owe. Uh-huh. Yeah, I mean, I think so. Yeah, probably. I mean, I don't know if the lawyer really shouldn't be pushing for the surgery. It's more like the lawyer should send you to a doctor. And if the doctor thinks you need the surgery, then, you should have it. I've never really heard about lawyers pushing surgery because, lawyers kind of have to stay in their lane, right? They're lawyers, they're not doctors. They don't know if you need a surgery or not. They could recommend a surgery to you. So, I don't know what you mean by pushing, but yeah, I mean, sometimes a lawyer can give you advice. Like they could say, look, if you do this surgery based on my opinion and based on my experience as a lawyer for 20 years, I think the case will be worth $1 million. But if you don't do the surgery, the case might be worth only, 200,000, 150. So I recommend you do it because it'll make you feel better. It'll also increase the value of your case. They can give you advice like that. So yeah, it should be fine, I think. And then Faded says, I settled my New York City car accident case with Chubb for the full 500,000 and signed the general release. How long until I get a check? Is the case now final and guaranteed? I have anxiety that something will happen. No, if you settled it, yeah, you'll get paid. I mean, no, it should be fine. And plus, Chubb is very good. Chubb is a big company. You should have seen if there was excess umbrella, though, because Chubb very often has excess umbrella. So, 500, but then they might have like 5 million excess. I don't know. If you settled it already, you probably can't go after the excess now because once you sign the release, you're basically saying that you agree to the 500. But, I'm just saying Chubb, a lot of the times I see that Chubb does have excess umbrella. It doesn't mean that they had it in this case. I don't know. Maybe they didn't. Maybe you already checked, and there was no excess umbrella. But no, don't worry about it. How long it takes, it doesn't take long. And maybe it takes 30 days. It could be a little bit longer if there are like some issues like liens or Medicaid, Medicare, things like that, right? Because sometimes the insurance companies don't want to release the check if there's like a Medicare issue, and you might have to wait longer than 30 days to get the Medicare information from Medicare because it's like the federal government. They're a little slow, bureaucracy, so it might take 60 days, 90 days, things like that. They don't want to give you the money without making sure. Sometimes the insurance companies want to pay like Medicare or, one of these lien holders directly. If it's a government like Medicare, Medicaid directly, because there's some laws out there that say that if they don't pay, then what happens is they could be the ones liable for the amount that is owed Medicare, let's say, plus times 3, like treble damages. And they don't want to, take that risk. So they said, look, I'll just hold the money until you find out how much the debt is, and then we'll just pay that directly. But if you don't have any liens, if there's no Medicare, Medicaid, it should just be like 30 days, maybe, to get the check. It shouldn't take too long. And then Pharaoh says, I got offered $30,000 for my rehabilitation. 12,300 was for me. My lawyer gets the rest. Should I take it? I don't know what you mean by 4-year rehabilitation. I'm not really sure. You mean for your case, like for the whole case, $30K to settle a case? I mean, it depends on the case, right? Every case is different. If it's a really soft tissue case, just a little chiropractic care, $30K is not bad. But if it's like a real serious case where you had surgery, well, then of course that's too little. So you'd have to really discuss that with your lawyer, or you can text me if you wanted a second opinion, or just ask another lawyer maybe in the community in your city and see what they think. But yeah, $30K, it's something. It's not a high number for sure. And then Jason says, thank you for all your videos. Deposition is a week away. You have helped me understand the process of all this and prepare to be hopefully a good witness. Oh, no, I'm glad that I was able to help. Okay, awesome. Congrats. Yeah, good luck in your deposition. Just remember, the important thing is just to listen to the question they're asking you and just be calm and try to understand what they're asking. And then, formulate the answer in your mind without speaking. You don't want to start speaking and you don't know where you're going, right? Like a train of thought. Just, listen to the question, understand what they're trying to ask you, answer it without speaking. And then once you understand like what they're asking, what your answer is that you've answered silently in your mind, then give them the answer and just keep it like short. The only time you should really talk a lot and really give a lot of examples is when they're asking you about damages. Like, what are the things you were able to do before that you can no longer do, or that you can still do, but not as well as you could before, the incident. There you can talk about things, right? Like day in the life. Like, for example, I can't sleep. I wake up. I can't get out of bed. I can't take a shower. I can't put on my socks. Go through a day in the life from when you wake up until you go to bed, and explain all the things and how it's affected you. Or maybe even think of some moments in time or stories. I have that list of I think it's a 13-page list of activities. And I've been emailing that to some people who've asked for it. I could email that or text it if anybody needs it. Just reach out to me also on that number, 347-566-9595, and I'll send it to you. So yeah, basically just lists like things that you wouldn't think of, but you could also think of like moments in time, or like, for example, family things or holidays like Thanksgiving, Christmas, vacations. How your life has changed because of the injury. You could think of people, you could think of things you love to do, right? The passions in your life, the people that are important to you in your life, anything like that. And think of some stories, moments in time. That's always good. And say some of that in a deposition. Oh, and Farrow also says, seems low because I'm not done with my treatment, but they're saying we can pay you out now for your treatment. I sustained a disc bulge and meniscus tear. Well, yeah, if you're not done, maybe wait and see. Because, for example, you have a meniscus tear, but what if like later, even 6 months from now, they say, well, the tear is not going to heal on its own. You're going to need surgery. Well, now it's not worth 30K. It could be worth like 330, right? Or 230 because you're 230,000 because you're getting a surgery. So, I would definitely make sure you finish with your treatment first. And then Money Dog asks, question, why is it that the defendants are asking for more time going on 4 years and they just want to lowball me for a TBI as well as a full knee replacement and hand surgery and elbow? Well, that's what the defendants do. They don't want to pay, right? Because if they paid you what you were asking and they paid you like full value, then it would be a lot of money out of their pocket. And they don't want to do that. They always want to, lowball. They always want to, save their money basically. And then they figure, because remember, a lot of these are big billion-dollar insurance companies. They're making a lot of money. So what they could do is they could invest the money in like some hedge fund in the stock market. Who knows where they're investing it, right? And money will grow. And then it's like the profits on all that money, they could use a little bit of those profits to pay you later. But if they paid you right in the beginning, they wouldn't be able to, they paid everybody right in the beginning. They wouldn't be able to keep growing the money. So they're always delaying. That's just this mode. That's just a standard operating procedure. It's like the status quo for them. They delay as much as they can, but that's why you need like an aggressive lawyer that knows how to prevent them from delaying. You just file motions, get the judge to tell them, no, this is the deadline, and just move everything as quickly as possible. And then Thaddeus says, how much is an L4, L5 worth? Well, an L4, L5 what though? Like a bulge or a herniation? Because L4, L5 are just levels in your spine, but so you'd have to, say, but even if it was, let's say, a bulge, remember, like, I can't tell you what something like that is worth. It depends on the case. It depends on the plaintiff. It depends on how you testify. It depends on the liability, the city, the lawyer. It's so many factors. So it's not really anything I could answer with any certainty. You know what I mean? Like L5, L4, like bulge, herniation, they're all going to be worth different. Like a L4, L5 bulge, if you fall, but there's not really anything wrong with the floor, or maybe you should have been looking where you were going and you're in the conservative venue, like maybe somewhere out in Texas, it might be worth zero. But, a different case where you got hit by a truck and you're in the Bronx, let's say in New York, and you have an L4, L5 herniation, even if you have just an injection, that could be worth 500,000. So it just depends on all those factors. That's why you can't really say, it's just like, what's a bulge worth? It's just too general. It's too general, Okay, and then Melquan says, my surgery for a 2-level back fusion was delayed for elevated temperature and some sort of body infection. How does this affect my case, which has been going on for over 3 years, and the insurance policy is $500K? Liability is in my favor. It shouldn't really affect your case. It depends on how long it was delayed for. Now, 2-level back surgery, of course, is going to be a major thing that's going to make the case worth many, many millions. But if you do it like, if it's delayed for like a month, it's not really a big deal. If it's delayed for like years, or you can't have it, then, you could say, well, look, I wanted to do it. I was already scheduled for it, but I just can't have it for medical reasons. So, but it sounds like it's not canceled, right? It's just delayed. So you should be fine. You just have to get it done once the infection clears, or, once that issue, the medical issue that's preventing them from doing it, is resolved. Just get it done. And then once you get it done, you'll still get the same value for it. And then Music Masty says hello. And Melquan has some other comment. Let me see if it, sometimes when I scroll, it was retracted. And then Thaddeus says, how much is L5S1 worth with surgery? Well, again, it depends on what L5S1, like if it's a herniation, but with surgery, it also depends what kind of surgery, right? Because you've like a fusion, like I was saying, could be worth millions, right? But not everywhere. Like some places, like I was doing a verdict search in Virginia, I saw a fusion's people are getting only 200,000, but in New York, a fusion is worth like at least $1 million usually, or close to $1 million. So, right, it just depends on where you are, and it depends on how the incident happened, how much insurance there is, a lot of different factors. You could check out some of the videos I did with, I think they're called like, how do you tell what a case is worth, or what are the factors? And then I list like some of these factors. There's maybe like 7 or 8 main factors, like the plaintiff, how they testify, how much insurance is there, what's the liability, who's at fault, what are the damages, what's the venue, where are you, right? Who's the lawyer, how they're preparing it, do they have experience, are they have a track record of getting this number that you're trying to get? So those all play a big role. So you can't just ever really ask like, what's a L5 herniation worth, even with surgery, because there's so many different types of surgeries. There's like fusions, which are the most serious, but there's also lighter surgeries like percutaneous discectomies or epidural steroid injections. But I've said before, like, for example, epidurals, I think, are worth usually from like 20, 30,000 up to maybe 100, 150. Percutaneous could be worth like 100,000 up to like maybe 300, 500. And then fusions could be anywhere from like 750 on the low end, at least here in New York, up to maybe even like 3 million, 4 million, 5 million plus, depending on how bad the fusion is. The important thing also to consider is not just the procedure you had, but the overall damages. Because remember, there are different categories of damages. So one of the categories is pain and suffering from the date of your incident up until the date of trial. So if your incident happened 3 years ago, well, you're entitled to pain and suffering, including loss of enjoyment of life, for 3 years. But you're also entitled to future pain and suffering from the date of the trial for the rest of your life. And the life expectancy tables, those are like the averages, show that people are living to like 83, 84 years old. So if you're like 30 and you're supposed to live to 84, well, you have like 54 more years of pain and suffering with this fusion, right? With this rods and plates in your spine. So that could be a real big, if it's presented the right way, if it's persuasive and it's explained the right way, that could be millions and millions right there, right? Plus, you're also entitled to lost wages, but you have to explain with an economist how much you were earning and that you can't work anymore. And then you get your lost salary. That's an element of damages. And remember, you don't just get one of these, you get all of these together, right? So you get past, you get future pain and suffering, including loss of enjoyment of life, you get lost wages. You also are entitled to future medical costs. So then, for example, if you have a surgery, like I had an L5S1 surgery case last summer, and the person was like 57 years old. And I believe that the economist, together with the doctor, provided a report that they thought future medical expenses were going to be like 2.6 million just for him, right? From 57 to like 83, 84, let's say, those years, all the medical expenses, because once you have a fusion surgery like that at L5S1, well, then you're going to need an adjacent segment disease, right? So that you might need the one at L4 as well. So that's another surgery that you could need. And if it's not S1, you won't need anything because S1 is the last one, right? There's nothing under S1. But if it's like L4, well, now you need L3 and you might need L5, right? Because L3, you might need L2, and then L4, you might need L5. So now you have two, and each surgery is like $100,000 surgery. But it's not just the surgery; it's also the MRI and the physical therapy and the hospital stays and this, and it all adds up. And plus, the getting diagnostic testing. So it all really, really adds up over your life. So just the medical costs could be into the millions. So that's what I really think is critical for like a good trial lawyer, is to like get all the categories that are available in your state, and you could look in the pattern jury instructions, they're right there, and then see how you maximize each category. Because why would you want to only go for like one category where you can go for like 8 different categories, right? Like wages and expenses and past pain and suffering, future pain, and then boom, 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 boom. And then even if they give you like small amounts for each category, but when you add it all up, it's going to be a big amount. So that's how you really maximize damages. Yeah, for sure. And then Carl C says, soon after filing a lawsuit, how long does it take to find an additional umbrella from your experience? Can the insurance company hog that information for long? I think you mentioned a motion to make them talk. No, I mean, that it depends on where you are. Like in New York, they have to tell you right away, like in the preliminary conference. Sometimes they don't tell you, but you can make a motion, or you could, usually they tell you without a motion, and you have to just really serve and like I said, in New York now, it's automatic. It's right in the CPLR. I think it's on 2 different sections actually say that they have to just give you the information automatically. But if they don't, you can file just a letter, or just quote the sections. I forget what they are off the top of my head, but they're CPLR 3317. No, I forget the numbers, but it doesn't matter. I have the template letter. So basically, you just send them the letter, and then basically, they just respond to it. And if they don't give it to you, sometimes they'll say we're not sure, or not available at this time, or upon information and belief. But that's all like hogwash. You just say, look, how much insurance do you have? And then usually they'll just tell you. If they don't, you can make a motion, and the court will force them to tell you. But yeah, it's usually pretty straightforward. It doesn't take too long, maybe 30, 60 days. You could usually find out. And then Anita says, defense lawyer says my thinking abilities and memory problems are not from my brain injury, and it's from menopause. This is a coincidence that I went into menopause a few years after my accident. What now? Well, yeah, that's why you just need a good traumatic brain injury lawyer, together with doctors like neurologists, neuroradiologists, neuropsychologists, or whoever you have treating you, to then come to court and explain that this is not for menopause, right? Because if your menopause happened years after your accident, well, what about, didn't you have these symptoms of the brain injury before the menopause, right? It can't just be So I think that what the defense tries to do is just tries to find any blame, right? Like they could, for example, I don't know, hurt somebody, right? And then just say, well, did you ever smoke? Maybe it's from smoking. Or did you ever eat like Doritos? Maybe it's from eating Doritos. And just make up anything. It's nonsense. So what you have to do is just have your experts, your doctors that are going to testify as well as your lawyer, just call them out and show why they're wrong and why you're right, just like any case, right? And that's who they believe, who the jury believes. Or, if you have overwhelming evidence, just like say, look, medically, it can't be from menopause. Here's all my evidence. So pay me X. And if you don't, that's fine. But your theory and your argument is so weak that if we have to go to a jury, it's not going to be X anymore. It's not going to be like $1 million. It's going to be like 5 million because you're making me go through the whole process and go to court over this nonsense. And it's almost like frivolous, right? It's like a frivolous defense. So you could bring that up. And then Machine says, are neck herniated discs more valuable than thoracic herniated discs? No, I don't think so. I mean, not really. I mean, I don't know of anything that like one herniation is more valuable than another across the board. It really depends on how it affects a person. Thoracic herniations are fairly like less common, but they could be pretty, bad. But neck herniations, of course, are pretty bad because that's like where you have a lot of nerve roots going with the dermatomes to like your fingers and things like that. Thoracic, I forget now exactly. They also have dermatomes, but it's more like lower down and just don't see that many thoracic. Sometimes you see a neck herniation that's so bad that it affects like the T1. It goes like I had that case where I think it went from like C3 all the way down to T1, and that was like a 5-level fusion, and we ended up getting like almost like we got 3.5 million on that one. So it could be really serious. But yeah, so I'm not aware of anything like across the board where like a lumbar is worth more than a thoracic. It just depends on how it affects you. And then Miguel Angel Lewis says, good afternoon, Arkady. After a process of 4 years, my last deposition was last month. How possible is it that my case can reach an agreement that at the end of the year they make an agreement? Bronx, New York. Either I can wait for an offer or it's too early. No, I mean, it's hard for me to say. You'd have to really ask the handling attorney, but it's definitely possible. I mean, if you've had your last deposition, it's primed, right? Because everything's done. Now, I would put the case on the trial calendar because in the Bronx, even if you file a note of issue and you certify the case as trial ready and that you're ready to go to trial like tomorrow, they're not going to give you a trial date tomorrow. They're going to give you a trial date like in 4 years because it's just backed up. It's a very busy court and it's not very efficient, even compared to like Brooklyn and Queens and Staten Island and Manhattan. Bronx is like one of the slower ones. So you'd want to get it on the trial calendar as soon as possible. But then, talk settlement with them, send them maybe one of these letters, like try to like settle settlement letter and see if you can give it. So it's definitely possible, but it's just like, I don't know. It would depend on, what their positions are. So you'd really have to ask your lawyer about that. And then Melquan says, my last question, do you have to proceed with a recommended surgery to obtain a policy limit? My case right now is over 3 years and going, is still below my medical bill, 100K plus, and policy is 500K. I mean, you don't have to if you've already had some other procedures or you've had some other injuries. It could be worth more than you could still get a big amount. If the policy is only 500, you could still get a big amount. You don't have to, but if the surgery makes sense, like in the sense that the doctor thinks you need it, your injury is not going to go away without it, and you're going to get a bigger amount if you do it, then go ahead and do it. So it just depends on if it makes sense or not. But yeah, you don't have to do surgery. And then Thaddeus says, don't settle if you not done with treatment. Yeah, no, I agree. Yeah, you have to be done with treatment first so you know all your injuries. And then Baby Boy says, I won't do a case, take the settle after discovery is closed in New Jersey. Take the settle after discovery is closed? I'm not sure I'm following that, but Faded says, thank you. It's been 30 days, so hopefully anytime now. There was no excess, unfortunately. All right, with the settlement. Yeah, so you should be getting it pretty soon. And Baby Boy also says, how much is a 3-level fusion, C4, C5, C6 hit provision worth in New Jersey? No, I mean, it could be big. I mean, 3-level fusion could be worth like 2 million, 3 million. It's hard for me to say depending on all the factors, but it could definitely be a big case. That could be a very big case. And then Faro says, I took a break from physiotherapy and they offered me to settle, but I only took a break because I received a cortisone injection and wanted to save my treatment plan. I didn't think I needed physiotherapy because I couldn't feel any pain due to numbness from the injection. Yeah, no, I'm sorry to hear that. That's pretty serious. No, so you maybe wait a little bit, get your treatment done, see if you need anything else, like any kind of surgery. But that case could be significant. That case could be worth more than 30. That was the one with they're only offering you 30K, right? So it could be worth a lot more than that. So yeah, I would wait a little bit. Okay, let me do a few more. Probably have to go pretty soon. MNV says, hi, Arkady. Just figured out how to find more info on your YouTube videos. We changed attorney on our case. Thank you for all your info that assisted us in making this vital decision. Last attorney. Oh, that's good. Yeah, no, you're very welcome. I'm happy I was able to help. And then Wen says, when with the ceiling collapse from LA, California, after 5 years of mediation and deposition with an August 18th trial date, we finally settled. Drum roll, settled for $975. My cut $310 though. I'm happy. Yeah, that's good. 975,000. That's pretty good. That's almost $1 million. Oh, congratulations. That's good. Yeah. What do you mean your cut is only 310? Oh, because you had a lot of liens, I guess, or other. Because the lawyer's fee should be like about 300 something. So you should really be getting closer to like 600. But unless you have liens or other expenses or other fundings. And then Shaq says, how do you think a jury feels about defense witnesses who constantly testify on behalf of insurance companies? Yeah, so that's one of the cross-examination points that you want to bring up, especially with these defense medical examiners, right? They call them IME doctors, independent medical examiners. They're not really independent. They're really defense medical examiners. And if they always testify for the defendant, you want to bring that up. You want to show how much money they make, that they're biased, that they're basically there like to say what the defense wants them to say, right? It's almost like a puppet, right? Like, or a jukebox, right? A jukebox. What do you do with a jukebox? You go up to a jukebox, you put in the money first, then you pick the song, and then the jukebox plays the song that you picked after you put in the money. So it's the same thing, right? They pay these doctors. They know what they want the doctors to say, and then the doctors say what they want them to say. So it's like a jukebox witness. So yeah, you could actually, I've said that actually at trial. I said, get rid of these, don't believe these jukebox witnesses. So you could definitely, the jurors usually don't like that. And then Jonathan says, Mr. Frekhtman, you're the best. I just want you to know that. You give everyone hope. Keep up the good work. Oh, thank you so much. And Thaddeus Johnson says, at my mediation, will they tell me how much the insurance is worth by the person at fault? Yeah, I mean, you can find that out before the mediation. Mediation is like an attempt to settle. So you all come to the table, you have a judge, and then you give them your idea what the case is worth. You negotiate the case. Like say, I want $1 million. They say, well, that's too much. I'll give you 200, and you see if you can come to a middle ground. But yeah, way before the mediation, you should know how much insurance they have, because otherwise, how can you go to a mediation if you don't even know how much they have, right? Like, for example, if they have $1 million, you might say, give me $1 million. But if they have $1 million plus like another 10 million, well, then you can say, wait a minute, I have these surgeries. It's not just worth $1 million. It's worth like, I want 3. So, but you can't make a demand and you can't really formulate value if you don't know what there is, right? Kind of. So that's like the first step. You have to know what there is available to you. And then MNV says the last fired attorney filed 3 wrong complaints unknown to us. Should I file a complaint with the bar before deposition so it is known we didn't change our story 3 times, but our last attorney did? Thank you. It's hard for me to say depending on what they did. You mean the lawsuit was wrong, the complaint? Uh, Probably better to text me. We could do a consultation about that. I mean, I don't want you to go filing a complaint against an attorney, if you don't have to. But you could explain that if it was an attorney mistake, your new attorney might be able to explain that without you having to go filing a complaint. Because I don't think filing a complaint really goes back to the court that the case is in. That goes more like to a different group. So it's more about whether the attorney should be punished or not, right? Not about the case. So, and then JRM says, my attorney or my depo is coming up on August 7th, 2025 for a trip and fall in a common area of rental property. So I'm quite scared and nervous. Any tips? Yeah, like I was saying earlier in this live, just like listen to the question, answer the question, do your best to only answer what they're asking. You could watch that video I made. It's called Super Depositions. And I think I kind of went through a lot of the questions that they ask and a lot of the answers and how to deal with it. Maybe I could do another video like that. But I think that one was pretty comprehensive. It was like 40 minutes and I kind of went through. I think I actually had the outline with me and I went through a lot of the questions in that outline. Just like an outline that we use where we have some of the questions that the defense lawyers ask, and we give our clients some guidelines, some advice. So that could be a helpful. I think it's called super depositions. Yeah. And then Anita says, in what circumstance will the defense not pursue a deposition of the plaintiff? My lawyer said they might not because of TBI. Well, yeah, if you have like a TBI, if you can't answer the questions, they might not want to depose you. They might want to depose someone else, maybe, who knows about either the incident or knows about your damages, depending on how bad the TBI is. But yeah, I mean, usually they do pursue the deposition of the plaintiff. Yeah, I mean, I'm trying to think what other instances. Sometimes they waive it. In New York, sometimes what happens is when you sue the city, they have a 50H hearing, which is similar to a deposition, and that's done before you file a lawsuit. So if they did a really comprehensive one and it's like a smaller case, they might say, well, we did a good 50H. We don't even need a deposition, and they'll just waive it. But it's usually not waived. It's usually they want to do it, especially like private firms, because they make money. They bill by doing the deposition. And then Carl C says, Mr. Frekhtman, I'm your client. Have you been busy in court lately? May we speak today or sometime this week? You have critical information. Yeah, sure, absolutely. Just text me. I guess just text me to that same number, 347-566-9595, and we'll let me drop my number in the chat. That's more of a number for new clients, for new consults, but I could schedule something with you as well if you're already a client. Absolutely. I'm happy to speak with you. And then King says, what if building owners do not respond to a lawsuit and my lawyer filed a judgment with the court? Does my settlement amount go up? Well, no, that wouldn't be a settlement, right? So if it's a default judgment, so you have a judgment. So basically you filed a lawsuit, they didn't answer. So then you filed a default judgment, meaning you get a judgment by default since they didn't answer, they didn't appear in the case. And then you have to try to enforce the judgment either by finding where they have, information subpoenas on different banks like Chase, TD Bank, whatever they bank, Bank of America, right? You find where they are and then try to take money for the judgment or assets, depending on who you're suing. But if they're building owners, they should have money. So it might just be that what they'll do later is they'll just open up the default judgment. They'll file a motion to vacate the default judgment, and then they'll try to appear in the case and say, look, we had insurance. We just, whatever, we lost the papers. We didn't get notified of it, whatever excuse they'll come up with. And the judge might do that and open it back up for them. So that's usually how that works. But yeah, it's not a settlement. A settlement is when you have somebody in the case and they want to give you money. It's like a contract. They're saying, I'll give you X amount of money in exchange for, you dropping the case. But this is more of a judgment because you don't even have anybody to talk to. It's just they didn't answer. So then you get a default judgment. But later on, it could lead to a settlement if they vacate and they come in with insurance, which is what you probably want. And he says, my case is also a ceiling collapse case, had shoulder and knee surgery, both arthroscopic. What is that worth in New York? It was also a negligence case. Yeah, I mean, ceiling collapses are good cases. If you had shoulder and knee, I would say at least like, maybe it could be worth anywhere from like 350 to 500,000 or more. It depends on all the, all the impact on your life, how serious it's been, how it's changed your life. But yeah, I mean, like shoulder surgery is pretty serious. Knee surgery is pretty serious, and a ceiling collapse case in New York City. Yeah, I mean, we've had cases like that, like shoulder and knee, and we've gotten in that range. I mean, some for like 300s, 500s, 650, 850, some even for more than $1 million. So it definitely has value. And Vinod says, "Hello, sir. Hi, how are you?" Okay, it looks good. I mean, we went through almost an hour, like for 50 minutes. We went through and we answered a bunch of questions. I have to get going, so I guess we'll try to do another one maybe later this week. Yeah, so thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Bye-bye.